Okay, hello there YouTube and all those who want to free Julian Assange. I've not quite finished my detailed statements of grounds ready for my judicial review or petition for a writ of habeas corpus on Julian Assange's behalf, but I want to test the linkages in my PDF export from Word. Specifically in relation to Julian Assange's submission to the United Nations Working Group on Arbitrary Detention, otherwise known as Wgad. The submission of Julian Assange is available online, as is the UN Wgad decision, judgment or opinion as it's referred to. Also the Swedish statement that the statement Julian Assange made to the Swedish prosecutors. But I'll press on because while the Julian Assange submission is quite substantial, its references are even more substantial, which I've endeavoured to include in this electronic submission. So let's begin the reading and the testing of the linkages herein. The applicant, Mr. Julian Assange, hereby submits an urgent request for relief to the United Nations Working Group on Arbitrary Detention and for an opinion regarding the arbitrary nature of the detention of Mr. Assange. For nearly 4 years, closer to 7 now, Mr. Assange has been deprived of a number of his fundamental liberties. For the last 816 days, he has been confined to the Embassy of Ecuador in London, in an area of 30 square meters. He has no access to fresh air or sunlight. His communications are restricted and often interfered with. He does not have access to adequate medical facilities. He is subject to continuous and pervasive form of round-the-clock surveillance, and he resides in a constant state of legal and procedural insecurity. Mr. Assange has not been charged. The above has come about in the following circumstances, each aspect of which has contributed an arbitrary element whose consequence has been or has become arbitrary detention. The key elements are his inability to access the full intended benefit of the grant of asylum by Ecuador in August 2012, the continuing and disproportionate denial of such access over a period of time in which its impact has become cumulatively harsh and disproportionate. The origins of the justification relied upon for his arrest to be pursued by Sweden under a European arrest warrant, and the way in which that request was validated and pursued with continuing effect to the present time. For the failure to acknowledge in Mr. Assange's case that UK law and the procedure has now been altered so that he would no longer, if facing arrest today, be liable for extradition under a European arrest warrant, and yet no benefit from the change in the law has been facilitated to him. This is not by choice. Mr. Assange has an inalienable right to security and to be free from the risk of persecution, inhumane treatment and physical harm. Ecuador granted Mr. Assange political asylum in August 2012, recognising that he would face those well-founded risks if he were extradited to the United States. The only protection he has from that risk at the time being is to stay in the confines of the embassy. The only way for Mr. Assange to enjoy his right to asylum is to be in detention. This is not a legally acceptable choice. The Wgad has agreed in previous cases that the deprivation of liberty exists where someone is forced to choose between either confinement or forfeiting a fundamental right, such as asylum, and thereby facing a well-founded risk of persecution. Link number 1. The European Court of Human Rights, link 2, and the UN High Commissioner of Refugees similarly adhere to this principle. The circumstances underlying the application for asylum and its grant by Ecuador Mr. Assange has been pursued and pilloried by the United States authorities since his organisation commenced publishing documents which revealed information that was perceived to be politically embarrassing for the United States, such as evidence that the United States soldiers might have been implicated in potential war crimes. Notwithstanding the fact that the publications of such information was a protected act of free speech and political expression, the United States commenced investigating Mr. Assange and WikiLeaks, and investigated a series of search and seizures and surveillance, and instigated a series of search and seizure and surveillance measures which do not appear to be regulated by any meaningful due process in which Mr. Assange is able to assert his rights. The stated aim appears to have been to restrict Mr. Assange's movements by any means possible. The investigation has been accompanied by a parallel public campaign of vilification, during which Mr. Assange has been identified as public enemy number 1 by several prominent Americans, some of whom called for his assassination. Unfortunately, I don't have the annexes of Julian Assange his submission here, except his affidavit. Let's just see if I can that returns me. Yeah. The likely fate of Mr. Assange, if he were to be extradited to the United States, has been illustrated by the trial and detention of alleged WikiLeaks source Private First Class Bradley Manning, hereinafter referred to as Ms. Chelsea Manning, who was, as confirmed by the Special Rapporteur on Torture, subject to inhumane and degrading treatment and sentenced to 35 years imprisonment. These events were the catalyst and factual foundations for Mr. Assange's decision to apply for political asylum at the Embassy of Ecuador. In parallel, Sweden had issued a European arrest warrant against Mr. Assange for the purposes of obtaining his presence in Sweden for questioning in relation to an ongoing investigation. Mr. Assange has never been charged. On 19th of June 2012, Ecuador granted Mr. Assange political asylum due to his well-founded fear of persecution and the probable legal and physical mistreatment he would face if extradited to the United States of America. A key factor in this decision was the refusal of either the United Kingdom or Sweden to issue any assurances that Mr. Assange would not be extradited onwards to the United States of America from Sweden. Mr. Assange had exhausted his domestic remedies in the UK, there having been findings against him in the High Court and the Supreme Court on two separate issues of law. There have now been decisions on those issues which have radically changed the position so that Mr. Assange, if he was extradited, if extradition was sought by Sweden today, would no longer face extradition. In the circumstances pertaining in June 2012, Mr. Assange feared the potential of onward extradition to the United States, sought asylum to Ecuador, which in turn announced that it had granted asylum to him. The United Kingdom issued a statement to the effect that it would arrest him if he tried to leave the confines of the Ecuadorian embassy for any purpose or under any conditions. That position has not been revised, nor any further statement made concerning his extradition to Sweden, although the UK has now revised its practices and the UK Supreme Court revised the law so as to accommodate and agree with the challenges raised by Mr. Assange to his extradition. Thus he continues in the position of his extradition having been ordered which would have been by now achieved had asylum not been granted by Ecuador. And yet where he would be the last individual to be extradited on a basis now acknowledged to be both wrong in law and in principle, and in violation of promises given to Parliament at the time of the introduction of the Extradition Act relating to the European arrest warrant. Sweden issued a European arrest warrant against Mr. Assange for the purpose of obtaining his presence in Sweden for questioning in relation to a claimed investigation. The claimed complainants have clearly indicated that at no time did either intend a criminal complaint to be made. The respective complaints, internally contradictory on the facts, and in the case of one indicating that pressure had been applied by the police, and further criminal proceedings shut down by a senior prosecutor, were nevertheless revived by a third prosecutor, sought out by a lawyer intent upon advancing a particular objective on behalf of the complainant. Mr. Assange has been denied rights of a defendant, including access to potential exculpatory evidence. The case has remained formally at the preliminary investigation phase and has now been frozen since 2010. Mr. Assange made himself available to the Swedish authorities for questioning in the United Kingdom and later at the Ecuadorian embassy, or to be interviewed by video link, but the Swedish prosecutor has refused these requests and has failed to give a reasonable explanation why. The prosecutor confirmed again recently that Ecuador's decision to grant asylum to Mr. Assange had no bearing on either her decision to rely on an arrest warrant to secure his presence for questioning. The Antisocial Behaviour, Crime and Policing Act 2014, now in force under Section 156, introduces a bar to extradition whereby an accusation will be insufficient to require extradition. Section 156 is clearly intended to and will change the way that UK courts approach the issue that arose in Mr. Assange's case in the High Court. Now a charge, rather than a preliminary accusation, will be required to facilitate extradition under a European arrest warrant. A number of countries have long insisted upon this. The UK has now brought its legislation and practice into conformity with a number of other European countries. Mr. Assange is not charged, only accused, and could now not be extradited from UK to Sweden. The recent UK Supreme Court decision in Bucknes versus Minister of Justice Lithuania and others decided that the fifth reason for refusal of the Mr. Assange's case in the challenge in the Supreme Court was wrongly decided. The court recognised that this fifth reason was, quoted, the only one that received any real endorsement, even in the other majority judgments in the case. Had the fifth reason not been factored into the decision in Mr. Julian Assange's case, the result would have been different, and by that route also his extradition would now, if decided today, be decided differently. In that case, the issue raised by Mr. Assange in the Supreme Court for the first time had argued that the requesting judicial authority could not be a prosecutor, as in the case in Sweden. Instead, the requesting authority must have the true hallmarks of a judicial authority, in particular independence from the executive. Mr. Assange's continuing position. Mr. Assange has now been detained in the Ecuadorian embassy for 816 days, but has spent a total of 3 years, 9 months and 6 days under different forms of detention. This exceeds the maximum permissible sentence he would serve if he was indicted and convicted in Sweden, and has become progressively increasingly incompatible with the presumption of innocence. His situation is uncertain and could be prolonged indefinitely. Notwithstanding the diplomatic immunities inherent in the position of the Ecuadorian embassy, Mr. Assange is subject to extensive 24-hour close visual and oral surveillance from the British police officers who are stationed within 1 or 2 meters of the embassy door and windows. The scale of this surveillance effort is such that the UK government has spent 7.3 million on the operation to date. This corresponds to approximately 16 persons monitoring Mr. Assange at the embassy at all times. The Ecuadorian authorities have also discovered a listening device which was planted in the embassy. Mr. Assange's detention and constant surveillance within the narrow confines allotted to him in the Ecuadorian embassy have taken a significant toll on his physical and mental health. The embassy self-evidently does not have the personnel or equipment to attend to him as and when inevitably a medical emergency will arise. Mr. Assange therefore faces an impossible dilemma. If he continues to remain in the Ecuadorian embassy, he risks irreparably damaging his health. If, however, he leaves at any juncture, he must, against his consent, renounce his fundamental right to asylum and expose himself to the prospect of unfair proceedings and physical and mental mistreatment in the United States of America. The British and Swedish authorities have evidenced no willingness to resolve this issue on a political level or within the framework of their respective legal systems. Mr. Assange therefore turns to Wgad in order to obtain an urgent legal adjudication of this impasse. This matter falls squarely within the jurisdiction of Wgad. 1. Mr. Assange is detained against his will and his liberty has been severely restricted. Against his volition, any individual cannot be compelled to renounce an inalienable right, nor can they be required to expose themselves to the risk of significant harm. Mr. Assange's exit from the Ecuadorian embassy would require him to do exactly that, renounce his right to asylum and expose himself to the very persecution and risk of physical and mental mistreatment that his grant of asylum was intended to address. His continued presence in the embassy cannot, therefore, be characterized as volitional. Mr. Assange's detention is arbitrary and falls under categories 1, 2, 3 and 4 as classified by Wgad. In particular, the context of his deprivation of liberty has arisen 1. From the failure of Sweden by initiating a process against him to obtain his extradition in the face of contradictory wishes expressed by complainants, having not established a prima facie case and refusing unreasonably and disproportionately to achieve a process of questioning him, if desired, through the normal processes of mutual assistance. Further, by his offer of cooperation in facilitating a number of alternate methods, short of being extradited to Sweden, where it is further stated as a matter of record that he will then be imprisoned in Sweden on arrival, and as a foreigner with no ties to Sweden in custody until trial. This situation is comparable with and likely more egregious than previous cases, which have elicited findings of arbitrary deprivation of liberty. As set out infra, the Wgad found in Abdi v UK and in the European Court of the Human Rights agreed that a deprivation of liberty exists where someone is forced to choose between either confinement or forfeiting a fundamental right and risking persecution. The Wgad defends the rights of asylum seekers, upholds the principle of non-refoulement, and eschews indefinite detention without judicial review. It has found arbitrary deprivations of liberty in situations of house arrest where individuals have had greater freedom of movement than Mr. Assange, and the Wgad has found the house arrest and extensive surveillance of Chinese activist Chen Guangcheng to be arbitrary detention. In 2012, the United States provided Mr. Guangcheng with diplomatic asylum in the US Embassy in China. Mr. Assange therefore requests the Wgad on an urgent basis to 1. Issue a declaration that his current situation constitutes arbitrary detention. 2. Require the United Kingdom authorities urgently to consider the effect of the changes in United Kingdom law and relevant precedents that, if previously implemented, would have resulted in the dismissal of the order of his extradition. 3. Require the authorities of the United Kingdom to give effect to Mr. Assange's right to asylum by allowing him safe passage to Ecuador. 4. Require the Swedish authorities to ensure that any law enforcement actions taken by them are compatible with Mr. Assange's right to asylum. And 5. As urgent interim measures, require A. the United Kingdom authority to give assurances that they will not arrest Mr Assange if he leaves the embassy for the purposes of receiving medical treatment, and that will permit Mr Assange to access open air and sunlight for the purposes of exercise, specifically and at a minimum in the roof space adjacent to the posterior part of the embassy, and B, the immediate removal of police surveillance, at the very least the police posted inside the embassy building. Mr Assange also respectfully invites Wgad to visit the embassy in order to assess both its proprietary and as a continued place of confinement. Its propriety as a continued place of confinement, including the unavailability of medical facilities and the level of surveillance to which Mr Assange is subjected. However, in the light of the urgency of this request, if such a visit would delay the ability of Wgad to issue an expeditious resolution on the matter, Mr Assange remains available to provide further evidence, for example affidavits from medical professionals, and subject to the consent of Ecuador, video or photographs of the amenities of the embassy. Go on, get down. Submissions. Mr Assange has been deprived of fundamental liberties against his will. The current physical and legal circumstances of Mr Assange can only be characterised as detention, predicated on a continuous deprivation of almost all of Mr Assange's liberties. In assessing a deprivation of liberty, Wgad focuses on effect rather than form. In Resolution 1997-50, the Human Rights Commission issued terminological constraints as to what constitutes detention when it entrusted Wgad with the task of investigating cases of deprivation of liberty imposed arbitrarily, providing that no final decision has been taken in such cases by domestic courts in conformity with domestic law, with the relevant international standards set forth in the Universal Declaration of Human Rights, and with the relevant international instruments accepted by the states concerned. Similarly, the European Court of Human Rights also underscores that the distinction between deprivation of liberty and restriction of liberty is one of intensity and degree. In citing the Wgad case with approval, the UK House of Lords noted the particular emphasis on the level of supervision of Mr. Wgad and the restriction of his movements and contacts with other persons. Mr. Assange has been deprived of the liberty, the ability to exercise a range of fundamental physical and personal liberties. He has no access to outside area, which is contrary to the requirements that all detained persons must have access to an outside area for at least 1 hour per day. Mr. Assange has a usable living space of approximately 30 square metres. The embassy is approximately 200 square metres. The Embassy of Ecuador can be a place of detention. In its Deliberation 5 on the situation regarding immigrants and asylum seekers, the Wgad concluded that relevant spaces of custody covered a broad range of spaces. House arrest under the conditions set forth in Deliberation number 1 of the working group, and confinement on board a ship, aircraft, road vehicle or train are assimilated with custody of immigrants and asylum seekers. The places of deprivation of liberty concerned by the present principles may be places of custody situated in border areas, on police premises, premises under the authority of a prison administration, ad hoc centres, so-called international or transit zones in ports or international airports, gathering centres or certain hospital premises. The Ecuadorian embassy, through no fault of its own, is unable to provide Mr. Assange with the range of medical treatment required by the United Nations body of principles for detention and standard minimum rules for prisoners. Due to the physical setup of the space allocated to him in the embassy, he is also subject to constant visual and oral surveillance by the British police who are stationed in the immediate proximity of the embassy. There is no indication that any judicial warrant, either by Sweden or the United Kingdom, has been issued for such continuous and intrusive surveillance. In many instances, the degree of the surveillance has intruded into Mr. Assange's right to privileged communication with his counsel. British police officers are stationed inside the embassy building, but out of its protected diplomatic space, as well as immediately outside the embassy, and are positioned to survey its interior throughout the street-facing windows. They are therefore able to overhear conversations conducted therein. Mr. Assange's visitors are also recorded by the police operation and are often questioned as to their identities upon ingress and egress from the embassy, regardless of their age or sex. Wgad has found that house arrest may be comparable to deprivation of liberty, provided that it is carried out in closed premises which the person is not allowed to leave. Mr. Assange is certainly confined in a closed premises, since he faces immediate arrest if he attempts to leave. It is no more accurate to claim that Mr. Assange is allowed to leave than it would be accurate to claim that a prisoner is free to attempt to escape from prison. The deprivation of liberty does not have a volitional component. It is internationally recognised in numerous Wgad and European Court of Human Rights cases, and by the UN High Commissioner for Refugees, that detention includes circumstances in which the only alternative to confinement is to renounce the possibility of claiming asylum. Mr. Assange continues residence at the Ecuadorian embassy cannot be described as volitional. If he leaves its perimeter, even to obtain fresh air or emergency medical treatment, he will be arrested and extradited, without assurances, to Sweden, and thereby subject to the very risk refoulement to the United States, which the asylum was afforded to him as protection against. This risk extends to a likely prospect that Mr. Assange would be subject to prolonged incommunicado detention, which falls foul of the prohibition on cruel and inhuman treatment. Forcing an individual to be indefinitely deprived of liberty as a condition for seeking or enjoying asylum violates the very principle behind the ICCPR International on Political Rights, Article 9's protection of both liberty and security of persons. States are subjected to particular intense scrutiny in relation to whether they have fulfilled their obligations to secure both rights in relation to the treatment of human rights defenders, including journalists and publishers in the field, such as Mr. Assange. The UNHCR, United Nations High Commissioner for Refugees, has long agreed with the principle that forcing one to choose between confinement or sacrificing a fundamental right to seek or enjoy asylum constitutes detention. It has long held that detention is confinement with a narrowly bounded or restricted location, including prisons, closed camps, detention facilities, or airport transit zones where freedom of movement is substantially curtailed and where the only opportunity to leave this area is to leave the territory. In line with this principle, the Wgad has previously found deprivations of liberty in circumstances in which the only alternative to confinement is to renounce a right, such as the possibility of claiming asylum, and face a well-founded risk of persecution. The Wgad considers whether asylum seekers have a real, as opposed to illusory, option to depart from confined areas. In which they must reside in whilst their applications are processed. In terms of the asylum seeker scenarios, the key aspects which transform such types of custody into arbitrary deprivation of liberty are the existence of guarantees for those persons held in custody, as well as the conditions of detention. These include the right to know the legal basis for the refusal to allow entry, the right to communicate with the outside world, including lawyers and family, the right to be brought before a judicial authority, the right to contest legal basis of the confinement, and to seek a remedy as concerns it, protection against excessive or lengthy confinement, and the right to be housed in a suitable environment. For instance, in the case of Abdi versus UK, Wgad found that the United Kingdom had violated Article 9 in circumstances in which a Somali asylum seeker was kept in indefinite detention because of his refusal to sign a letter agreeing to return to Somalia. Wgad rejected the argument that Mr. Abdi's confinement was volitional because of his refusal to sign such a letter and thereby consent to being returned to a conflict zone. In Wgad's view, the case raises in stark terms the question of whether or not the state is entitled to detain an individual indefinitely if he refuses to return voluntarily to a conflict zone. In any event, it is questionable whether a return to Somalia made under threat of indefinite detention would be said to be voluntary in any real sense. The Wgad found Abdi's detention to be arbitrary. The European Court of Human Rights also confirmed that Mr. Abdi's situation amounted to arbitrary detention in terms of the volition aspect. The court agreed that the option to leave and risk persecution is not a trump card, justifying the United Kingdom's Home Secretary to detain someone indefinitely. In Arbitrary versus Lebanon, the Wgad instructed Lebanon to respect the principle of non-refoulement, even where the applicant refused to voluntarily return to Iraq, because no contracting state may expel an asylum seeker or return a refugee to a territory where his life or freedom may be at risk. Similarly, in the case of Amour v France, the European Court of Human Rights rejected the argument of the French government that because the asylum seekers were free to depart from a French airport transit zone where they were held for 20 days, the restrictions on their liberty should not be qualified as arbitrary deprivation of liberty for the purposes of Article 5 of the Convention. In Mykolenko v Estonia, the European Court of Human Rights found a violation of Article 5 where an applicant refused to cooperate with his deportation, making his expulsion virtually impossible, as for all practical purposes it required his cooperation, which he was not willing to give. This was in view of the extraordinary length of the applicant's detention and the fact that the situation made removal impossible, and therefore the continued detention was not serving any purpose. Finally, the European Court of Human Rights also found a violation of Article 5 in the case of Riyadh and Idiab versus Belgium due to the lack of legal certainty or procedural safeguards in relation to the application's continued confinement in an airport transit zone for 15 and 11 days respectively, after the asylum request had been rejected. Despite the fact that the applicants refused on a number of occasions to board flights that had been booked for them, the court dismissed Belgium's arguments that the applicants had been free to move and in particular to leave the Belgian territory. The court held that the mere fact that it was possible for the applicants to leave voluntarily could not rule out an infringement of the right to liberty. The court noted in particular that the zone was an unsuitable place for residents and the lack of adequate social or humanitarian assistance, and lacked adequate social or humanitarian assistance. The grounds for finding an arbitrary deprivation of liberty are even more pronounced in the case of Mr. Assange. Unlike Mr. Abdi or the applicants in the Amour case, Mr. Assange has been formally granted asylum. It is therefore it is neither necessary nor appropriate as a matter of law for the Wgad to second guess whether Mr. Assange will face a real risk of persecution or physical harm. This must be presumed for the purposes of this application. It therefore follows that, as in the case of Mr. Abdi, neither United Kingdom nor Sweden are entitled to present Mr. Assange with the non-choice of remaining within his confines of the Ecuadorian embassy or subject himself to the risk of persecution and harm. As in the Amur case, Mr. Assange cannot be expected to leave the Ecuadorian embassy of his own volition, as concrete and reliable assurances regarding non-refoulement have been refused. The duration of Mr. Assange's confinement in the Ecuadorian embassy greatly exceeds the length of confinement in the Amur and Riyadh cases. The Ecuadorian embassy also lacks the necessary facilities and humanitarian services for prolonged residence. Mr. Assange has also been subjected to severe and prolonged uncertainty regarding his status. His detention is indefinite and therefore arbitrary. In line with the Amur case, the refusal of British and Swedish authorities to acknowledge or give effect to the political asylum granted to Mr. Assange has frustrated both his asylum and his right to an effective remedy. The Wgad has interpreted its mandate to extend to the following forms of arbitrary deprivation of liberty. When it is clearly impossible to invoke any legal basis justifying deprivation of liberty, as when a person is kept in detention after completion of his sentence or despite an amnesty applicable to him. Category 1. When the deprivation of liberty results from the exercise of the rights or freedoms guaranteed by Articles 7, 13, 14, 18, blah 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 of the Universal Declaration of Human Rights, and insofar as states parties are concerned by Articles 12, 18, blah 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 of the International Covenant on Civil and Political Rights. Category 2. When the total or partial non-observance of the international norms relating to the right to a fair trial established in the Universal Declaration of Human Rights and in the relevant international instruments accepted by the states concerned is of such gravity as to give the deprivation of liberty an arbitrary character. This is category 3. When asylum seekers, immigrants or refugees are subjected to prolonged administrative custody without the possibility of administrative or judicial review of or remedy. Category 4. And when the deprivation of liberty constitutes a violation of international law for reasons of discrimination based on birth, national, ethnic, social origin, language, religion, economic condition, political or other opinion, gender, sexual orientation or disability or other status, and which aims towards or can result in ignoring the equality of human rights. In the present case, the arbitrary nature of Mr. Assange's confinement in the Ecuadorian embassy is grounded in the following factors. A1. The failure of the United Kingdom authorities to give effect to the changes in its own law, both in the Supreme Court decision and in legislation, either to provide Mr. Assange with assurances regarding non-refoulement or safe passages to Ecuador. Categories 2 and 4. The disproportionate nature of the actions taken by Swedish prosecutors, including the insistence upon the issuing of a European arrest warrant rather than pursuing questions with Mr. Assange in the United Kingdom as provided for by mutual assistance protocols. The indefinite nature of his detention and the absence of an effective form of judicial review or remedy concerning the prolonged confinement and the extremely intrusive surveillance to which Mr. Assange has been subjected, categories 1, 3 and 4, and the absence of minimum conditions accepted for prolonged detention of this nature, such as medical treatment and access to outside areas. Each will be addressed in turn. British and Swedish authorities refused to either provide Mr. Assange with assurance regarding non-refoulement or safe passage to Ecuador. Mr. Assange has been deprived of his liberty by virtue of his attempt to exercise his fundamental inalienable right to seek asylum from political persecution and physical harm. After the Ecuadorian authorities announced that they had granted political asylum to Mr. Assange, the Foreign Secretary of the United Kingdom, Mr. William Hague, issued the following statement. We will not allow Mr. Assange safe passage out of the UK, nor is there any legal basis for us to do so. The UK does not accept the principle of diplomatic asylum. It is far from a universally accepted concept. The United Kingdom is not party to any legal instruments which require us to recognise the grant of diplomatic asylum by a foreign embassy in the United Kingdom, in this country. This statement is wrong for two reasons. First, even if the UK does not recognise diplomatic asylum, it cannot escape its obligations to recognise the asylum granted to Mr. Assange as a protection against refoulement and the risk of cruel and inhuman treatment. To the extent there are exceptions, they do not apply. Second, the UK is wrong to not recognise Mr. Assange's asylum because customary international law requires it to do so. These arguments will be explored in detail. The United Kingdom and Sweden are obliged by applicable law and convention obligations to recognise the asylum granted to Mr. Assange, and no exceptions apply. Article 14 of the Universal Declaration of Human Rights sets out that everyone has the right to seek and enjoy in other countries asylum from persecution. The mandate of Wgad recognises the binding nature of the right to asylum, set out in Article 14 of the Universal Declaration of Human Rights. Through its explicit recognition that a violation of this right can give rise to a claim for arbitrary detention, the establishment of further category of arbitrary detention pertaining to asylum seekers must also be considered to be reflective of Wgad's recognition of the binding nature of states' obligation to, firstly, consider and ensure an effective remedy for asylum seekers, and secondly, ensure that the mechanisms for considering such applications do not consign the applicants to prolonged or arbitrary deprivation of liberty. The most important aspect concerning Mr. Assange's right to asylum is that he faces a real risk of cruel and inhumane treatment. The Special Rapporteur on Torture has found that, at a minimum, Mr. Assange's alleged source, Ms. Manning, was subject to cruel and inhuman treatment. He also expressed the opinion that Ms. Manning had been subject to a prolonged period of isolated confinement with a view to coercing her into cooperation with the authorities, allegedly for the purposes of persuading her to implicate others. The only reasonable inference from this is that Miss Manning was subject to such mistreatment in order to obtain against Mr. Assange. Accordingly, apart from the fact that the mistreatment meted out to Miss Manning acted as a litmus test concerning the fate of Mr. Assange if he was to be extradited to the United States, it can already be concluded that any proceedings in the United States would be tainted through the use of such information extracted through such measures. These aspects, both cumulatively and independently, give rise to an erga omnes duty on all states to take necessary measures to protect Mr. Assange from such fate. Asylum as a protection against refoulement is one such measure. Conversely, non-recognition of Mr. Assange's asylum undermines his protection against cruel and inhuman treatment and is thus incompatible with the UK's and Sweden's respective obligations under the Convention Against Torture. As confirmed in official correspondence from the authorities of Ecuador in granting Mr. Assange asylum, the government of Ecuador found Mr. Assange had a well-founded fear of being persecuted for reasons of his political opinions in the form of his WikiLeaks work. It was also found that there is a real risk of retaliation by the country or countries related to the information published by Mr. Assange, and that this retaliation may endanger Mr. Assange's safety, liberty, and even his life. It was also found that Mr. Assange's circumstances made him unable and or unwilling to avail himself of the protection of Australia, the country of his nationality. In his announcement of the asylum decision, Ecuador's Minister of Foreign Affairs, Chancellor Ricardo Patino, explained that the principles applicable to asylum case of Mr. Assange, mainly the principle of non-refoulement, are enshrined in the set of instruments, standards, mechanisms and procedures provided for the corpus of the international law, including the Convention on the Status of Refugees and its 1967 protocol. The government of Ecuador notes that the Charter of Fundamental Rights of the European Union in Article 18 recognises the right to asylum. Ecuador's decision to grant asylum was clearly motivated by the risk he faced of political persecution and physical harm, and issued within the framework of the protection against refoulement as set out in Article 14 of the Universal Declaration of Human Rights, and the numerous other conventions to which Ecuador is party, which are detailed in the asylum decision, including the 1951 Convention, to which the United Kingdom and Sweden are contracting parties. If a contracting state undermines the objective of the grant of asylum by extraditing a refugee who has been granted asylum by another state to the state which was the source of the risk which formed the basis for the asylum, the protection or asylum state may justifiably object to the potential refoulement of its refugee. In such a case, the refusal to accept the latter's determination of status, followed by extradition of the refugee, constitutes a putative wrong to the protecting state. Article 33(1) of the 1951 Convention further prohibits any contracting states from expelling or returning a refugee, irrespective as to which state granted the refugee status, to a territory where his life or freedom could be threatened on account of political opinion inter alia. The broad wording of the article protects refugees from expulsion to any territory which constitutes such a risk. The fact that a refugee has been granted asylum due to a risk linked to State A protects the refugee from expulsion to State B if it would also face a similar risk to life or freedom there. The terms of the 1951 Convention also do not specify or require that asylum applicants must be physically present in the state where asylum is requested. The prohibition on expulsion to any territories where the refugee could face a prohibited risk also applies to expulsion from embassies. The Human Rights Committee also accepted that the expulsion of a dual Iraqi-US national from the Romanian embassy in Baghdad to the US authorities could have engaged Romania's responsibilities if it had been foreseeable at the time of the expulsion that there was a risk that the person's rights would be violated. This case suggests that far from breaching international law by refusing to expel a person, wanted by the territorial state, the embassy authorities would in fact violate international law if they were to expel the person, notwithstanding the existence of real risk or harm or violation of that person's rights. No exceptions apply to the obligations to recognise Mr. Assange's asylum. In the 1978 statement, the United Nations High Commissioner for Refugees Executive Committee formally concluded that the very purpose of the 1951 Convention and the 1967 Protocol implies that refugee status determined by one contracting state will be recognised also by other contracting states. Refugee status as determined in one contracting state should only be called into question by another contracting state when it appears that the person manifestly does not fulfil the requirements of the Convention. Both the United Kingdom and Sweden are contracting parties to the 1951 Convention. Neither the UK nor Sweden have claimed that Ecuador committed a manifest error in granting asylum to Mr. Assange, nor would there be any evidentiary basis for them to do so. Apart from the 1951 Convention, Article 18 of the Charter of Fundamental Rights in the European Union also provides that all members of the European Union must guarantee the right to asylum with due respect for the rules of the Geneva Convention of 28th July 1951 and the Protocol of 31st January 1967 relating to the status of refugees and in accordance with the treaty establishing the European Community. Article 14, paragraph 2 of the Universal Declaration of Human Rights sets out a narrow exception to the right of asylum, which may not be invoked for the case of prosecutions genuinely arising from non-political crimes or from acts contrary to the purposes and principles of the United Nations. Shut up! Mr. Assange falls outside of the scope of any reasonable interpretation of this exception. Over the last 4 years, he has been subject of a highly politicised United States national security investigation, unprecedented in its scale and nature. The United States investigation arises out of Mr. Assange's publishing activities, which are protected under the United States First Amendment. Article 19 of the Universal Declaration of Human Rights, Article 19 of the International Covenant Protecting Political Rights, and Article 10 of the European Convention on Human Rights. On the 19th of June 2014, 54 organisations, including Human Rights Watch, the American Civil Liberties Union, and Article 19, signed an open letter to the US Attorney Eric Holder demanding that he drop the ongoing investigation against Mr. Assange. The intervening Swedish arrest warrant has been issued for the purposes of questioning Mr. Assange in order to determine whether the preliminary investigation in Sweden will lead to an indictment. When Mr. Assange entered the Ecuadorian embassy, the embassy released a statement that Mr. Assange's presence in the embassy should in no way be interpreted as the government of Ecuador interfering in the judicial processes of either the UK or Sweden. The Ecuadorian authorities granted asylum to Mr. Assange after 2 months of detailed consideration of his case, and after all attempts to secure diplomatic assurances concerning refoulement failed. Mr. Assange has also repeatedly attempted to ensure that the exercise of his fundamental right to asylum does not hinder the Swedish preliminary investigation, for example by making himself available to be interviewed in the Ecuadorian embassy or via video link, by submitting a written statement, or by seeking assurances that he will not be refouled to the United States. There is therefore absolutely no basis for finding that it has been invoked in the sense implied by Article 14.2 of the Universal Declaration. For the same reasons, the exceptions to the 1951 Convention are also inapplicable. Mr. Assange faces a serious risk of refoulement to the United States. Article 19.2 further provides that no one may be removed, expelled or extradited to a state where there is serious risk that he or she would be subject to the death penalty, torture or other inhumane degrading punishment. Provisions such as these were relied upon by Ecuador as part of the basis for its decision to grant asylum to Mr. Assange. Since both the UK and Sweden are members of the European Union, it would be unlawful and thus arbitrary for them to disregard these obligations. The hypothetical possibility that diplomatic assurances might be obtained in the future, i.e. after the asylum seeker is expelled, has been rejected by the European Court of Human Rights as unacceptable. In Amour v France, the court ruled that the fact that France had obtained diplomatic assurances from Syria prohibiting onward extradition to Somalia after asylum seekers had already been expelled from the French territory did not satisfy France's positive duty to protect asylum seekers from harm. The court emphasised that the possibility of departure becomes theoretical if no other country offering protection comparable to the protection they expect to find in the country where they are seeking asylum is inclined or prepared to take them. Although the UK Foreign Secretary averred to Ecuador in October 2012 that the UK would work towards producing a legal text to secure Mr Assange's human rights protections, no such assurances or legal texts have been produced or finalised. In June 2013, the UK abandoned plans to form a legal commission in order to formulate such a text. Its withdrawal from this process coincides with the reports concerning the assistance provided by Mr Assange to Edward Snowden in relation to the attempt by the latter to exercise his right of asylum. Notably, Sweden has recently been found by the Committee Against Torture to have contravened its obligation to take adequate steps to protect persons in its territory from the risk of torture or cruel and inhuman treatment. In that particular case, Sweden allowed Mr Agiza to be secretly apprehended and handed over to the CIA at Bromma Airport in Sweden, where he was shackled and forcibly administered sedatives by suppository before being flown to his country of origin, Egypt, and subsequently imprisoned and tortured. The committee also concluded that the mere provision of diplomatic assurances was an insufficient measure to protect the applicant due to the absence of any binding mechanism for their enforcement. The Human Rights Committee also found that in the Alziri case that Sweden had violated Article 2 and 7 of the International Covenant protecting political rights by allowing Mr Alziri to be rendered by the CIA to Egypt, where he was subject to ill treatment and failing to conduct an effective criminal investigation in relation to the actions of the Swedish authorities who had allowed the rendition to occur. The fact that these instances were not isolated cases is further underscored by reports that the Swedish secret police recently facilitated the rendition of 2 of its nationals from a secret US-run prison in Djibouti to the United States. These cases evidence the fact that Swedish authorities are both highly susceptible to pressure from the United States of America and willing to ignore their obligations under human rights treaties and conventions in order to maintain their relations with the United States. This is particularly the case with anything WikiLeaks related. For instance, a senior Swedish intelligence advisor expressed in state media the position that Sweden's close intelligence cooperation with the United States would be jeopardized by Mr. Assange's activities in Sweden. The United Kingdom has also demonstrated its willingness to assist the United States of America in relation to its CIA Extraordinary Renditions Programme, which contravenes the UK's human rights obligations. The UK and Sweden have an obligation to ensure Mr. Assange's asylum and non-refoulement, or at very least to consider it as a relevant factor when determining the necessity and proportionality of the continued execution of Sweden's arrest warrant. Both Sweden and the UK have therefore violated their duty to provide concrete assurances that Mr. Assange will never face proceedings where he could be subjected to inhumane and degrading treatment or punishment. The right to asylum and related protection against refoulement is recognised under customary international law. The states must prioritise claims of asylum over bilateral extradition as obligations. Significantly, the International Criminal Court has recently referred to the right to political asylum and its related protection against refoulement as having attained the status of jus cogens. The ICC found that although it was obliged by virtue of the terms of the Article 93(7) of the ICC statute to return 3 detained witnesses to the Democratic Republic of Congo to stand trial there, it could not fulfill this obligation if to do so would frustrate the right of the detained witnesses to claim asylum from the DRC in the territory of Netherlands. The ICC, International Criminal Court Appeals Chamber, ruled that it was obliged to release witnesses from the ICC detention unit onto Dutch territory in order to give effect to these witnesses' right to claim asylum in the Netherlands. Since the claim was pending before the Netherlands, the ICC had no competence or legal authority to continue to detain them in the ICC detention unit, or to take measures that could interfere with the ability of the Dutch authorities to give effect to the witnesses' right to an effective remedy as concerns their asylum claims. In the same manner that the ICC found that it would be illegal and arbitrary for it to continue to detain the witnesses in the ICC detention unit or to frustrate the ability of the witnesses to enjoy an effective remedy should the application be successful, it is illegal and arbitrary for the UK to obstruct the right of Mr. Assange to enjoy an effective remedy as concerns his asylum application addressed to Ecuador. i.e. through safe passage to Ecuador. Diplomatic asylum under customary international law. Although diplomatic asylum is not the only basis for asylum asserted by Ecuador, states have a right under customary international law rule to grant diplomatic asylum, and this right is universal. Whenever states have been asked to grant to an individual diplomatic asylum, they have done so in a way that evidenced their belief in an existing customary norm. This is not only the general practice of the states, but also a general practice accepted as law, as set out in Article 31b of the Statute of the International Court of Justice. Numerous states have promoted the institution of diplomatic asylum, including Australia, Austria, Belgium, Canada, France, blah blah blah, and the United States. The United Kingdom has frequently granted diplomatic asylum on humanitarian grounds. Famously, it was prepared to grant diplomatic asylum to a large number of persons in its embassy in Tehran under the Shah. There is a rich history of states granting diplomatic asylum throughout the 20th century. During the Spanish Civil War, 14 embassies and legations granted asylum in embassies and legations in Spain. 8 of these were Latin American, the rest European. In August 1989, West Germany granted diplomatic asylum to numerous East Germans. Several states granted diplomatic asylum to various Albanians in 1990. In China, in 2002, foreign embassies granted diplomatic asylum to Northern Korean defectors and ultimately secured their safe passage. The United States Embassy in Budapest granted diplomatic asylum to Cardinal Mindszenty in the period of 1956 until 1971, when a resolution was brokered by the Pope. In many of these cases, the asylees were afforded safe conduct out of the embassy and out of the country. Reports and resolutions drawn up by bodies such as the International Law Association and the Institute Detroit International point in the same direction as the general practice of states summarized above. The general practice of states in relation to granting of refugee or asylum in embassies or legations is based on a humanitarian directive that has entered into general practice accepted as law. In order to be effective, this rule contains the duty of the territorial state to grant safe conduct. As Jamaica observed in 1975, the regime of diplomatic status will be ineffective without the corresponding obligation of territorial states to grant safe conduct of the asylees out of the country. Further, the rule of customary international law has been given expression in the Organization of American States, OAS, Treaty on Asylum and Political Refuge in 1939, which has been ratified by 15 OAS states. In the 1954 Caracas Convention on Diplomatic Asylum, which also codifies the right to grant diplomatic asylum, as well as the duty of the territorial states to guarantee safe conduct, has been ratified by 14 OAS states. The Caracas Convention gives expression to this rule of logic and of general international law in Article 12. Once asylum has been granted, the state granting asylum may request the asylee be allowed to depart for foreign territory, and the territorial state is under an obligation to grant immediately, except in case of force majeure, the necessary guarantees referred to in Article 5, as well as the corresponding safe conduct. Finally, the International Court of Justice in Asylum recognises that asylum protects the political offender against any measure of a manifestly extra-legal character which a government might take or attempt to take against its political opponents. Nonetheless, Peru and many other Latin American states subsequently became parties to the Treaty on Asylum and on Political Refuge of 1939, which broadens the ambit of the right of states to grant diplomatic asylum, as compared with the 1933 Montevideo Convention. Oh, be quiet, Jubbly. Even if, as a matter of substance, the United Kingdom and Sweden consider that they are not obliged to recognise or give effect to the asylum afforded to Mr. Assange, as a matter of process, they were still obliged to ensure that their disagreement did not effect of depriving Mr. Assange of his liberty in an arbitrary and protracted manner. At very least, they were obliged to take steps to ensure that their disagreement with Mr. Assange's right to remedy did not prejudice the following rights: his presumption of innocence, his right not to be detained for an unreasonable length of time, his right to defend himself, his right to receive appropriate medical treatment, his right to be housed in an appropriate premises, his right to receive legal advice without being monitored or the fear of being monitored, his right to appropriate facilities to receive family visits, and his right to fresh air and sunlight and outside exercise. The disproportionate nature of the Swedish prosecutor's refusal to interview Mr. Assange outside Sweden. For over 2 years, the prosecutor has refused to consider alternative mechanisms which would allow Mr. Assange to be interviewed in a manner which was compatible with his right to asylum. For example, the prosecutor has rejected requests to interview him via video link, to interview him in the premises of the Ecuadorian embassy, to receive his written statement, or to secure assurances from the Swedish authorities regarding non-refoulement to the United States of America, should Mr. Assange travel to Sweden for the interview. Even if the decision to issue an arrest warrant against Mr. Assange was in accordance with Swedish law at the time it was issued, the lawful character of this decision has been vitiated by the disproportionate and grave nature of its consequences. In a press conference on 16th of July 2014, and in response to the question why Mr. Assange had not been charged, the prosecutor replied, "The Swedish Code of Procedure places obstacles. The procedural code requires that we give the suspect a chance to give his version. The procedural code requires that the specific accusations are shared with the defendant at an interrogation. The procedural code further requires that we give the suspect access to the entire case file before we are able to lay charges. The suspect should have had the ability to ask for additional investigative measures. Once all these steps have been taken, it is possible to indict. None of these prospective steps detailed by the prosecutor have been taken. The principle of proportionality is a fundamental principle of international law which applies to the protection of human rights, particularly in the area of deprivation of liberty. For example, remand in custody on criminal charges must not be reasonable and necessary. Must be reasonable and necessary in all circumstances. The Wgad has also referred to the principle of proportionality as a principle of international law which influences the right not to be arbitrarily detained. In Communications 5/5/2011 and 4/2011, Wgad held that the principle of proportionality always requires that detention be used only as a last resort, and that when it is used, strict limitations and effective judicial guarantees must be in place. Mr. Assange has made himself fully available to be interviewed by the Swedish prosecutor in a range of ways. The prosecutor has refused to explore any of these options. The arrest warrant should be considered to be the last resort when the prosecutor has not explored any other options. In this regard, even if the prosecutor had concerns regarding the efficacy of such alternative options, the principle of proportionality dictates that the prosecutor should first examine in practice whether the alternative methods are indeed adequate. In a press conference on 16th of July, the Swedish prosecutor said, "Even if it were possible to hold interrogations with Mr. Assange at the embassy, I do not know whether it is legally possible. Then the question still remains about how would a prosecution, if one were to be brought, be able to be held? How would we conclude this if we wish to prosecute and hold a trial when he has said that he absolutely refuses to come here? I cannot go into any further detail about the considerations I've made, but in short, these considerations have led to the conclusion that at present there are no reasons to try out this complicated process, which would consist in repeated applications for legal assistance in criminal matters. It is grossly disproportionate and unreasonable that the prosecutor simply dismissed these possibilities on the grounds of entirely hypothetical concerns that might never have eventuated. Chapter 23(4) of the Swedish Code of Judicial Procedure, the primary instrument governing the rights of accused during preliminary investigation, provide that the investigation should be conducted so that no person is unnecessarily exposed to suspicion or put to unnecessary cost or inconvenience. The preliminary investigation shall be conducted as expeditiously as possible. When there is no longer reason for pursuing the investigation, it shall be discontinued. A review of Swedish practice prepared by 16 prominent legal NGOs for submission to the United Nations Human Rights Council demonstrates that Swedish prosecutors routinely interview persons outside of Swedish territory, pursuant to the international agreement which allows and facilitates such process. Suspects in both less serious and more serious preliminary investigations have been interviewed in Germany, the United Kingdom, Serbia, and even in the Swedish consulate in the United States of America. The disproportionality of the prosecutor's decision is also aggravated by her failure to take into consideration Mr. Assange's fundamental right to asylum, especially in the context of the refusal of the Swedish authorities to provide assurances regarding non-refoulement. The prosecutor has alternative mechanisms to secure information from Mr. Assange. If Mr. Assange leaves the confines of the embassy, he forfeits his most effective and potentially only protection against refoulement to the United States of America. Any hypothetical investigative inconveniences regarding the interview of Mr. Assange by video link or by the embassy pale into insignificance when compared to the grave risk that refoulement poses to Mr. Assange's physical and mental integrity. Since the preliminary investigation has not been progressed since 2010, it has not been completed in violation of Mr. Assange's right to a speedy resolution of the allegations against him, as per Article 14 of the ICCPR, International Protection of Rights, Covenant on Protection of Rights. The existence of a confidential preliminary investigation against Mr. Assange was unlawfully disclosed to the media by the Swedish Prosecution Authority within hours of its commencement. In August 2010, since that time, Mr. Assange has had no means to dispel this long shadow of suspicion, whereas the complainants have been interviewed several times. Mr. Assange has been deprived of the ability to be heard and to clear his name. The prosecutor's refusal to interview him in the Ecuadorian embassy is therefore contrary to the presumption of innocence and the right to a fair proceedings, as it prolongs the suspicion against Mr. Assange, which simultaneously depriving him of the means to contest it. By virtue of the fact that Mr. Assange has been denied the opportunity to provide a statement, which is a fundamental aspect of the aude alteram partem principle, and access to exculpatory evidence, Mr. Assange has also been denied the opportunity to defend himself against the allegations. This is contrary to the Principle 11 of the Body of Principles for the Protection of all Persons under any form of detention or imprisonment. The prosecutor is also fully aware that the practical consequences of this decision is that Mr. Assange is compelled to remain in the confinement of the Ecuadorian embassy. The guidelines on the applicable criteria and standards relating to detention of asylum seekers and alternatives to detention of 2012 stipulate that where asylum seekers are detained, the authorities must justify it in accordance with principles of necessity, reasonableness and proportionality, showing that less intrusive means of achieving the same objectives have been considered in the individual's case. The prosecutor has failed to comply with this requirement. This failure to consider alternative remedies has therefore consigned Mr. Assange to a lengthy pre-trial detention, which greatly exceeds any acceptable length for an uncharged person. Mr. Assange has been confined in the embassy for over 2 years, approximately 27 months. The maximum sentence which Mr. Assange would face if convicted in Sweden is 4 years. And under European rules on sentencing, he would be released after 2/3 had been served, even without including the 10 days in prison and the 550 days under house arrest. Mr. Assange has been detained for 84% of the maximum time which he would have served if charged, sentenced and convicted. Including his detention prior to entering the embassy brings the figure to well over 100%. The duration of such detention is ipso facto incompatible with the presumption of innocence, even though the arrest warrant was issued for the purpose of questioning in order to determine whether the matter will proceed to a formal investigation. The fact that he has now been confined for almost 4 years due to the allegations will necessarily affect and influence the appearance of impartiality of the Swedish decision makers. Since both the Swedish prosecutor and the Stockholm District Court have refused to consider Mr. Assange's confinement under either house arrest or in the embassy as a form of detention, he has been denied the right to contest the continued necessity and proportionality of the arrest warrant in light of the length of the detention. All be quiet. All be quiet. This constitutes a violation of the principle that detainees must have the right to contest the continued necessity of their detention on a regular basis in a court of law. This applies to all situations of deprivation of liberty. In turn, the courts, prosecutor and domestic authorities must take measures to protect the detainee against an unreasonable length of pre-trial detention and asylum seekers from prolonged periods of confinement. Whether it is reasonable and necessary to continue to insist that a person be detained pursuant to an arrest warrant will necessarily change with the effluxion of time during which the person has been detained. Mr. Assange is effectively serving a sentence for a crime for which he has not even been charged. The Swedish authorities have nonetheless refused to acknowledge that this confinement should be taken into consideration for the purposes of calculating sentence if Mr. Assange were to be convicted of any crime. His continued confinement therefore exposes him to a likely violation of nemo debet bis vexaro pro uno et idem causa. If convicted in Sweden, he will be forced to serve a further sentence in relation to conduct for which he has already been detained. This is contrary to Article 14 paragraph 7 of the International Covenant protecting political rights. His continued confinement in the embassy beyond the period of 32 months, which will be in February 2015, would also give rise to Category 1 form of detention. The absence of any form of judicial review or remedy concerning the prolonged confinement and extremely intrusive surveillance to which Mr. Assange has been subjected. Although the United Kingdom indicated in 2012 that it would establish a working group to regulate Mr. Assange's situation, it has failed to do so, thus depriving Mr. Assange and the Ecuadorian authorities of a mechanism through which they could attempt to resolve or mitigate the violations of Mr. Assange's rights. Both the United Kingdom and Sweden have refused to recognise Mr. Assange's confinement as a form of detention, and as such he has had no means to seek judicial review as concerns the length and necessity of such confinement in the embassy. As set out above and in Annex 1, Mr. Assange has been continuously subject to highly invasive surveillance for the last 4 years. Mr. Assange has never been disclosed a legal basis for these particular surveillance measures, and in fact has little ability to do so, as the United States national security investigation against him is still underway. He has thus been deprived of the ability to contest their necessity or proportionality. These intrusions must be considered in the light of the context of Mr. Assange's work as a publisher and in the impact that they have had on his freedom of speech and the freedom of the press. The cost of policing the embassy has been estimated at $7.3 million to date. A Freedom of Information Act submitted in April 2014, which requested a breakdown of the cost of policing the embassy, was rejected on national security grounds inter alia. This expenditure and the related surveillance measures clearly exceeds the range of measures which are either necessary or proportionate as concerns the simple execution of an arrest warrant. Such round-the-clock surveillance is a gross deprivation of privacy and thus personal liberty, and over a prolonged period can constitute inhumane treatment due to its psychological effects. The intrusive nature of this surveillance has also undermined the right to receive legal advice in a confidential setting. As noted above, listening devices have been discovered in the premises of the embassy, as found by the European Court of Human Rights. The right to effective representation will be rendered illusory in circumstances in which the defendant could be monitored, irrespective as to whether the defendant is monitored in each instance. It must also be emphasised that the current surveillance regime is part of an ongoing campaign of surveillance and deprivation of liberty, which commenced in 2010. This campaign has targeted Mr Assange's right to free speech and political belief, free movement, privacy and privileged legal communications. Most importantly, by vilifying him as an enemy of the state and a high-tech terrorist, this campaign has engendered a significant risk as concerns his physical safety. A columnist in the Washington Times wrote, "We should treat Mr Assange the same way we treat any other high-value terrorist target. Kill him." The former Chief of Staff to the Vice President Dan Quayle proposed the following in the Weekly Standard: "Why can't we act forcibly against WikiLeaks? Why can't we just use our various assets to harass, snatch or neutralise Julian Assange and his collaborators wherever they are?" When the Washington Times published a blood-splattered depiction of Mr Assange in the crosshairs of a rifle, the United States authorities took no steps to condemn such actions. Notwithstanding the Senator Gifford precedent, the refusal of the United Kingdom and Sweden to either recognise Mr Assange's asylum in a safe country such as Ecuador or provide assurances must be viewed as particularly arbitrary and unlawful in the light of the prospective positive duty to ensure that he is not subject to clear risk of harm. Mr Assange is also being deprived of the ability to be informed of the legal nature of these measures or to contest them in a court of law. Notwithstanding the submission of multiple freedom of information requests, neither UK nor the United States authorities have provided with him any information on these matters under the basis that the investigations against him are ongoing. The fact that Mr Assange has been denied the right to contest such measures is both a denial of his right to challenge such interference with his liberty and privacy and a denial of his right to an effective remedy, which is preemptory norm of international law. Mr Assange is effectively in a legal vacuum concerning these issues and is residing in a prolonged state of uncertainty, which is in itself severely deleterious to his mental health and contrary to the due process requirements set out in the above Amur and Wgad cases. The cumulative effect of the above conditions is the creation of a state of severe mental anguish and distress, particularly since this situation appears likely to continue indefinitely, as found by the European Court of Human Rights in relation to the situation of persons detained pursuant to indefinite immigration orders. Uncertainty regarding their position and the fear of indefinite detention must undoubtedly have caused the applicants great anxiety and distress, as it would virtually any detainee in their position. The prospect of indefinite confinement is, in itself, a violation of the requirements set out by the Human Rights Committee that a maximum period of detention must be established by law and upon expiry of that period, the detainee must be automatically released. Notwithstanding Mr. Assange's appreciation for the ongoing protection extended to him by the Ecuadorian embassy, the embassy is nonetheless exactly that, an embassy, and not a house or detention centre equipped for prolonged pre-trial detention. For the purposes of this urgent application, the most concerning aspect is the lack of appropriate and necessary medical equipment or facilities, as can be verified by Wgad through a visit to the embassy. If Mr. Assange's health were to deteriorate, or if he were to have anything more than a superficial illness, his life would be seriously at risk. The lack of access to medical and dental facilities runs contrary to Principle 24 of the United Nations Body Principle for the Protection of All Persons under any form of detention or imprisonment, and Article 22 of the Standard Minimum Rules for Treatment of Prisoners. The likelihood of Mr. Assange's health deteriorating increases the longer Mr. Assange remains detained in the embassy. Mr. Assange has no access to direct sunlight and thus vitamin D or fresh air. Thus, in turn, violates the requirement that all detainees must be afforded at least 1 hour of exercise outside, weather permitting. Further, it violates the requirement that in accommodating detainees there must be due regard to climatic conditions and particularly to cubic content of air, minimum floor space, lighting, heating, ventilation. Due to limited space within the embassy, Mr. Assange is unable to meet with his lawyers in a privileged settings, contravening Article 93. And it is also not feasible to receive family visits in such an environment, contravening Article 92. Conclusion. This is an application framed by political events, but at its heart it is about a person who has been deprived of his liberty in an arbitrary manner for an unacceptable length of time. If all the names, details and events were redacted, it could be distilled into the simple and irrefutable fact that a political refugee who has never been charged has been deprived of their liberty for nearly 4 years and confined in a very small space for over 2 years. The matter has come to a head because his mental and physical health are imperiled. This situation does not only affect him but also his young children who are being denied the protection and affection of their father. The situation is in urgent need of remedy. Wgad has both the power and the duty to grant it.